The Supreme Court takes up two big cases as President Trump challenges the autonomy of so-called independent agencies, and as a Republican Senate campaign arm tries to invalidate legal limits on coordinated election spending.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues on the editorial page, columnists Kim Strassel and Alicia Finley. Any fifth grade civics students can explain that the United States government has three branches: the legislative, that's Congress, the executive, led by the president, and the judiciary. But now Washington these days is full of so-called independent agencies. So where do they fit in, or is that even constitutional? That's the question of the Supreme Court on Monday in a case involving the Federal Trade Commission. The law that created the FTC in 1914 says that its members cannot be fired by the president except in case of malfeasance or other bad behavior. The Supreme Court upheld that idea in a 1935 case called Humphrey's Executor. But President Trump argues that he's in charge of the executive branch and he has the right to fire commissioners at will if he dislikes their policies or for no reason at all. Let's listen to a piece of the oral argument today. This is Solicitor General John Sauer tangling with Justice Elena Kagan.
If there's one thing we know about the founders, it's that they wanted powers separated. They wanted the executive, the legislative, the judicial. They didn't want them all in one place. They wanted them separated across the government, across the different branches. Easy enough to agree with, right?
I agree with an important caveat that the court said he didn't see the law, that the one, exception to all this division was the presidency itself, where the framers consciously adopted a unified and energetic executive.
Well, that's not a caveat. That's actually, that's like the not X to my X. Because what I was saying was, and maybe you knew where this was going, so you had to have this caveat, which is really a fundamental contradiction. But the idea is that the president was supposed to do the executing. But he wasn't supposed to do the legislating, and he wasn't supposed to do the judging. And here's like my next proposition, which I think you have to agree with because we just look around the government and it's obviously true. Some people think it's a real distortion from what the founders thought, but these, what you think of as executive branch agencies, including independent agencies, right? They do a lot of legislating.
Kim, kind of an interesting almost admission there from Elena Kagan. These executive agencies look like they're doing a lot of legislating these days. But what's your overall read of this argument of the Supreme Court? And 1935, this is a 90-year-old precedent. What has gone wrong with these executive agencies?
Well, everything has gone wrong, and we can blame Woodrow Wilson for many, many things. One of them is that he thought he was smarter than the founders. He had this big idea that government should just be run by an expert class. And the FTC is an example of that vision. So you have these commissioners that cannot be fired for anything other than malfeasance or bad behavior. They're not really accountable to anyone. And we have now dozens upon dozens of agencies that operate this way. Congress created them. If you think about it, it's actually almost every area of our economy is governed to a certain extent by these agencies. Finance, the Federal Trade Commission, Securities and Exchange Commission, Labor, the National Labor Relations Board, and OSHA. Communications, the FCC, Consumer Product Safety Commission, Energy, the Federal Energy Regulatory Commission. It just goes on and on. And some agencies, I should note, do have independent status, but because their directors are accountable to the president, these are outfits like the CIA or the EPA, they're considered independent executive agencies. And because their directors can be fired, they're not really at risk in this. But the problem we have here is we've got these agencies. The Supreme Court said, back in 1935, I guess we can have these bodies of experts that do quasi-judicial and quasi-legislative functions in the executive branch. And that was the fundamental error back then, is just thinking that it was okay and somehow consistent with the Constitution that you can have these agencies that just have a little bit from Article 1 and a little bit from Article 3 and a little bit from Article everywhere. And that's not really what the Constitution set out. And so we have all these outfits that are not accountable really to anybody in the end. And over time, while they might have maybe just had quasi functions, these days they have total function. They make the rules. They legislate, as Elena Kagan said. That's a job for Congress. And that's really the way these things should be laid out. Congress can pass the laws, and then the executive branch is there to execute them and administrate them. And I understand her argument that, well, this is the way it is now, but that doesn't mean it's the way it should be. And that is the major choice is being put in front of the Supreme Court right now.
The case on Monday was brought by a former FTC commissioner, Rebecca Kelly Slaughter, who was fired by Trump earlier this year. There's a similar case percolating in the courts about an attempt by President Trump to fire a member of the National Labor Relations Board, other cases at other agencies. The 1935 precedent here, Humphrey's Executor, essentially the court said there that Congress intended the FTC to be a body of experts and, as Kim lays out, doing quasi-judicial, quasi-legislative functions, not being part of the executive branch. That was the theory behind setting it up and insulating it from direct presidential control. So to be clear, the president nominates members of the FTC, but under the current precedent cannot remove them. But the difficulty is, Alicia, I mean, President Trump's argument here is that Humphrey's Executor was wrong the day it was decided because the FTC always had executive functions. But then it goes on to make a pretty good case, I think, that over the years, on that understanding, Congress has expanded its remit pretty dramatically. The government's brief says the FTC now administers or enforces some 80 laws regulating, among other things, movie tickets and meat products. It says today's FTC can bring civil enforcement suits against private parties, promulgate binding rules, issue final orders in administrative adjudications, and investigate potential violations of the law, unquote. And then, Alicia, one of my favorite bizarre facts about Washington is that the FTC also enforces antitrust law in some cases, and in other cases, the Justice Department enforces antitrust law. As a reminder, one of those, the FTC is supposed to be insulated from the president. The other is not. The Justice Department is a cabinet agency. The president can remove the attorney general whenever he wants. And when the DOJ and the FTC can't agree on which of them should take the lead on some kind of merger review, they flip a coin. And my understanding is that doesn't happen all the time, but it does happen occasionally. And so the idea that it's so important that the FTC be insulated from presidential control, but whether one body or another is going to review this merger depends literally on a coin flip. There's some contradiction in that argument.
Well, right. So the just on that discrete point, the DOJ and FTC do kind of split up certain industries where they review certain. So media tends to go to DOJ, healthcare and drug mergers or drug companies that usually falls under the remit of FTC. But again, all of this is really just arbitrary. And they depends on just the two different departments or agencies getting along. And this has just been historical tradition, but there's nothing in the law that says that the FTC considers this merger or the DOJ considers that merger. It's just based on historical tradition. Now, to your other points, I think that's all very true. The Congress has over the years expanded the remit of the FTC in part because it didn't trust the DOJ in some cases. It didn't trust the president's appointees to enforce antitrust laws enough. So it ceded increasing amount of powers to the FTC as kind of a bulwark against presidents. Now, in my view, really the DOJ should be the primary enforcer of antitrust laws, and maybe the FTC has some other, other authorities it can use. but it has really, to both your and Kim's point, has expanded its purview way beyond what even during Woodrow Wilson's term or Woodrow Wilson intended. And you saw that especially during Lena Khan's reign of terror over the last 4 years during the Biden presidency, in which she sought to basically use this provision in the FTC Act that bars unfair methods of competition. And what does that mean, right? The Congress didn't really explicate it in the law. And so she essentially defined it, provided this guidance. As she said, well, we'll know it when we see it. And it is whatever we decide to define it as. And then she decided, in some cases, it was a quote unquote non-competes agreements. And those would be where employers bar their hirers from going to work for competitors for a certain period of time after hiring them. This was, of course, nowhere found in the law, but she just essentially took the vague powers that Congress delegated to the agencies and vastly expanded them, and essentially arrogated executive and more legislative powers unto herself and the agencies. So to kind of bring this back around, I think one of the problems is that these agencies have just become, constitutional abominations in the way that they mix all three powers. Executive, legislative, judicial. The Supreme Court has started to chip away at some of that, reining them in. For instance, the Jarkessi case a few years ago, in which the Supreme Court required agencies to actually go to federal courts when they're actually kind of trying cases that would normally be in front of juries, such as private rights. And so it's been kind of trying to rein in that administrative state and the excesses bit by bit, case by case. But I think this case before the court raises a much bigger and broader issues of whether it's even constitutional to combine all three powers.
On that point, the removed FTC commissioner here, Rebecca Kelly Slaughter, has a couple of arguments on her side. One, Kim, is she points to some earlier examples. So there was a commission that was set up in 1790 to help retire some Revolutionary War debt. And apparently there were a couple members of that 5-member commission who could not be fired by the president at will because they were the Chief Justice and the Vice President of the United States. I guess my read is that there are a few sporadic examples of that throughout history, particularly focused on things like retiring debt. It does not strike me as a very strong legal constitutional precedent for this alphabet soup of agencies that now we have in Washington making binding rules on free citizens and then investigating and enforcing those rules. The other thing she says is she points back to this past 90 years of experience that now we have. And she says the Supreme Court should be wary of overturning that kind of on a whim. So here's a line from a brief. She says, Congress structured dozens of administrative agencies in reliance on the rule of Humphrey's executor. She says, in effect, it was assigning the executive branch power that Congress otherwise might never have conveyed. And, Kim, there is something to that argument. If Congress saw what the Supreme Court ruled in 1935 and said, okay, we can create these independent agencies, we can hand this power off to some other body to make rules, on the understanding that there's going to be a little bit of insulation from whoever is sitting in the Oval Office. So let's do it again with the NLRB, and let's do it again with the SEC, and over again. It does create kind of a difficult cleanup job, even if you're convinced that the Humphrey's executive decision is wrong and should be overturned.
Well, sure, but I would make the case that arguing that something is so wrong and has become so terribly wrong over the years that we now can't fix it is really no argument whatsoever. And here's a reality. There would be enormous benefits if this were to be overturned, not just from a constitutional perspective, meaning in terms of clarity of the law and going back to the founder's vision. Everyone, all the critics of the court want to point out, as this as this brief does from Slaughter, that, Armageddon is going to follow, and look at all the terrible things that could happen. And we've had all these laws and agencies that have been created based on one premise. And now how do we move forward if you get rid of that premise? I get it. But first of all, one of the benefits of this is it will simply restore some honesty and reality to what's already happening on the ground. The reality is that none of these agencies are really insulated from the president. There are a few that have rotating members on the board, where sometimes the person in charge is opposite of whoever the president is at the moment, the party that is in power. But that's very rare. Usually there's these musical chairs. Once a new president comes in, he gets the person he wants at the top. He gets a majority on these agencies, and they're direct extensions of the executive branch. And with that clarity comes the reality, will be a reality for Congress, that if that's really how we're gonna operate in Washington, and let's just all be honest about this as a situation and clarify it constitutionally, then Congress is going to have to rethink whether or not it really wanted to cede as many powers as it has to the executive branch. It's essentially already done that, as noted. Alicia was talking about Lena Khan. She was a direct extension of Biden administration policies. She was not some insulated expert class that was making her own decisions. She was taking orders from the White House, just like everybody is, like FCC Chair Brendan Carr is right now from the Donald Trump administration. So Congress is going to have to stop, think hard, and decide whether or not it really wants to continue allowing those agencies, if they are under now unquestioned executive branch control, to continue to have the vast array of powers that they do. And honestly, I think that's a kick in the butt that Congress needs. It's been pretty lazy over the last 80 years. And this is one of the reasons why it's been allowed to offload a lot of its own duties to these independent agencies. It's almost forgotten how to write laws and to engage as the legislative branch of Congress, and putting this challenge back on them, saying, hey, you guys need to claw back some of your powers and do your own part in the separation of powers and maintaining your role in government. I think that would be healthy for our current situation.
To that point, Alicia, I agree that Lena Khan seemed like she was not obstinate to the agenda of President Biden, and the same with Brendan Carr. Maybe there is a difference in giving the president the additional power to say, do this or I will fire you. I understand why people are wary about this. I think that media company should lose its broadcast license, for example. And if you don't do that, I'm going to fire you and find a new FCC commissioner. That's a different sort of power dynamic. But I agree that maybe that should cause Congress then to have second thoughts about how much power it has handed over willy-nilly to these agencies over the decades. Maybe it will cause voters to take more seriously the job of picking a president who can be a faithful and trusted administrator of the executive branch and all of the power that flows into those agencies under that big executive pyramid under him. And by the way, at least if something goes wrong, there will be some democratic accountability. People will know who to blame, unlike this situation we have right now, where if people don't like what happens at the FCC or the FTC, how do they vote in response to that? Because the president can't fire that person. The next president can pick the successor, but sometimes these terms, the FTC's terms, for example, are 7 years long. So there is a real issue here.
Well, I think most voters don't really even understand if you tell Humphrey's executor that really they have no clue how these agencies even work. They don't know that they just assume that these agencies are completely under executive control. And for the most part, it really is kind of a pretense to, as we've been talking about, that these are quote unquote independent. There's no doubt that they actually, the leaders or the heads of these agencies answer and are directed by the president. We saw that with executive orders under Biden, now under Trump, directing the heads of these executive agencies, namely the FTC and the FCC, but there have also been to the SEC to undertake certain actions And so they are actually answering to the president. So I think that to Kim's point earlier, I think there would be a salutary effect of kind of removing this pretense, and that does reduce the democratic accountability insofar that the person is answering to the president. The leader or head of an agency is responding to presidential orders and presidential pressure, but in some ways it isn't directly accountable nonetheless to the president.
Kim, what about the Federal Reserve? Notable, the Supreme Court already earlier this year suggested that the Fed, at least its monetary policy decisions, might be different, might be an exception to this unitary executive theory of the president managing the executive branch directly like this. Do you suppose that holds, given that the Fed also has, regulatory responsibility over the financial system, or what does the Supreme Court do on the Fed?
Well, this has been the thing that critics of the court and those who are very worried about Humphrey's executor like to throw up the example. As Federal Reserve, this would be disastrous. The Federal Reserve, it really is important that it be insulated from the White House so that it can truly make some sound decisions about the economy without politics in getting in the way. And we need this for stable economic policy. I would note, I think the Supreme Court is highly aware of this question, and it's been kind of fascinating. It has been signaling that it knows that Humphrey's executor is a problem, has grown into a bigger problem, and it's slightly chipped away at it. There was a case that involved a firing that Trump did in his first term, the Consumer Financial Protection Bureau. In that case, the court held that the firing was permissible because the CFPB is run by a single director rather than a multi-member board. And John Roberts went out of his way to describe Humphrey's executor as applying to multi-member agencies that do not wield substantial executive power. So they were already starting to make some distinctions here. And lay out that there might be, different scenarios that apply in different situations. We have had the court already say that. The majority signaled this year that an end to Humphrey's didn't necessarily need to affect the Fed's monetary policy, since it pointed out that the Fed is uniquely structured entity with a distinct historical tradition. So I wouldn't be surprised here that the court very clearly seems to have laid the groundwork to allow itself potentially to put forward a decision here that does get rid of Humphrey's executor, overturns it when it comes to many independent agencies, but doesn't necessarily apply that to the Fed. And I wouldn't be surprised if you did see some distinctions like that. The court could absolutely do something like that. There's a lot of different ways to cut and carve up and describe some of these agencies and come up with a judicial precedent that perhaps gets rid of many of them, but might have a few exceptions.
Alicia, let's save a few words for the argument the justices are going to hear tomorrow. This is a challenge by the National Republican Senatorial Committee to some campaign finance rules limiting coordinated spending between candidates and political parties. What's at stake here?
So the First Amendment, I would argue, very broadly is at stake. Now, what is at issue in this case is the coordinated limits under this 1971 campaign finance law that restricts how much candidate committees can spend in coordination with national parties. And this varies depending on the state and the political office. With more populous states, candidates and parties are allowed to coordinate more on messaging and how they spend money. I think what's important here is to note that this campaign finance kind of a monstrosity that has grown over the years. The Supreme Court has kind of started whittling back with some important precedents. The Citizens United case that declared that corporations and unions could spend unlimited amounts independently. A McCutcheon Supreme Court case in 2014 did away with the aggregate contribution limits for an individual. So it's basically people could contribute an unlimited amount of money among candidates and parties. The reason why the Supreme Court has been doing this is because it has reflected that political speech and political contributions and spending is protected by the First Amendment. This Buckley v. Vallejo decision back in the 1960s or 1970s really kind of drew an arbitrary distinction, saying, well, the Congress can't limit political spending, but can limit political contributions. Now, that's really a distinction without a difference, which Clarence Thomas has argued. And I think that was further muddied by a Supreme Court decision in 2001 that has basically allowed these coordinated limits on coordinated campaign spending under the grounds that that they really are limiting contributions. Now, again, it's very complicated, but I think the bigger picture is that these limitations on coordinated spending really have weakened parties, and I think contributed to more polarization and political extremism.
Kim, we'll give you the last word here. The First Amendment implications, I think, are real in this whole line of cases the Supreme Court has been taking up. Remember the argument in that Citizens United case where they were asking, could this allow Congress to ban books? And the government was acknowledging that, yes, it could. I also wonder whether the Supreme Court might be putting us on a path toward a healthier politics, because I think part of the story of these campaign limits is an effort, a good government effort, to get so much money out of politics, out of campaigns, and it just pushes the money somewhere else in politics. So instead of having strong parties that are coordinating a lot with their candidates running under their brand, you end up with more super PACs and independent expenditures where the candidate, it's money that is going to support the candidate, but the candidate can also say, I'm not responsible for that ad. That's from a super PAC, right? And you get more outsiders that are challenging people in party primaries from the left or the right, hostile takeovers of political party lines on the ballot, more or less, because you have centralized parties that do not have the wherewithal to, really pick and choose which candidates they want to coordinate with and help run under their brands.
Yeah, there's so many reasons why we should hope that the court here does get rid of these limits. I mean, the first of them is just, this is also very much like Humphrey's Executor about correcting a judicial wrong. It's a sin that doesn't go back quite as far. It goes back, as Alicia noted, to the 1970s and Buckley v. Vallejo, when the court first, fell for the argument that these contribution limits and transparency rules were needed to prevent corruption in politics. We can all look around and be like, to that sentiment now. But the bigger problem is that by agreeing to them, they ran straight entirely up against the First Amendment, both in terms of free speech, because money is speech, but also the transparency rules they adopted, and this is a separate issue, but very much ran up against freedom of association and laid the groundwork for some of the targeting and intimidation we see of donors these days. And that's something else the court has had to be cleaning up. But the bigger problem, Kyle, as you note, is it's boomeranged. I mean, the biggest point was that, they did this because it was supposed to help get money out of politics. Well, the reality is that, these restrictions have simply made campaign spending a lot less efficient, requiring, candidates and the people who back them to spend even more money, which is the opposite of what Congress intended. And, just to note Congress here, it ought to have cleaned up some of this a while ago, but of course it never has. But the other thing, as you note, is it just funnels and diverts a bunch of money instead to organizations that people can't really identify and don't really know who they are. I mean, and that's the point is, when you're turning on your TV, would you rather see an ad that sort of straightforwardly says this ad in favor of this candidate is coming to you courtesy of the National Republican Senatorial Committee, or one that says this ad was paid for by United We Love America or something like that? You have like no idea who it is.
Americans for Loving Puppies.
Yes, Americans for Loving Puppies, and that's what we have these days. So I think there's a real hope that if this were to get overturned, or if they were to get rid of these limits, we might get back to some more accountability in politics. And let's just all acknowledge that as something Americans really are desirous of at the moment.
Thank you, Kim and Alicia. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button. And we'll be back tomorrow with another edition of Potomac Watch.